Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara, Law of Torts. Yesterday in the class we discussed at length whether it is a law of tort or law of torts. It is a law of tort supported by Winfield's theory, stating that every civil wrong which is not a civil offense or civil case, then you can take it as the tort, and the remedy can be in the shape of unliquidated damages. Suppose if it is not a tort, the court has to hand up, raise his shoulders up and say we can't do anything, which the court cannot say. Likewise, Salamond's theory or Pigeon hole theory of a law of torts says that there are specified or named torts, and slowly you can create another theory, another pigeon hole, stating whenever a new tort arises, like negligence, like nervous shock. All these things were not there in the 14th century. Negligence is a concept in 19th century, Dono versus Stevenson. Likewise, this nervous shock was a concept also in the 19th century. So like that, nowadays law of torts is more prevalent. Because when the century, with the advent of the advantage of advancement of the law, normally certain times the intention will also be taken into consideration. Please remember, malicious intention. I told in the case of Mayor of Bradford Corporation versus Pickles, 1895 case. Even though he dug deep into his in his fields and actually the water from the municipal corporation percolated into his area, we could not do anything because there was no legal injury, even though it is with malicious intention. Likewise, another such case I am going to tell you today. It is a famous case law called as Victoria Park Racing and Recreation Grounds Co. Limited. Victoria Park Racing and Recreation Grounds Co. Limited, Racing Club versus Taylor, Taylor, 1957. Right? Here it is a negative example. First, let us understand the case law. Here, these people, Victoria Park Racing and Recreation Grounds, they are conducting the so-called horse races. They are conducting some other games and tournaments in their grounds. Adjacent to the grounds, the field of Taylor is located. The land of Taylor is located. You know what this man has done? He has constructed or he has erected a tower and he used to sit in the tower and watch the races. Fine. He could observe the races on the plaintiff's race course. So to some extent this is excusable because it is his land. Already I told you he can do whatever like in his land. But what he has done is later the defendant allowed a broadcasting company to describe the races, which was done so effectively that the plaintiff sustained loss through failing attendance. So this tower, he has let it to a broadcasting company. So the broadcasting people came there, they used to comment, this horse is running for, this is a come on, like మన cricket match ఎప్పుడు చెబుతారే running commentary. Alaga, he has allowed the tower to be used by a broadcasting company for comments, and as a result of which people staying in the houses, మా చిన్నప్పుడు క్రికెట్ మ్యాచెస్ కూడా మేము వెళ్ళడానికి అంత డబ్బులు ఉండేవి కాదు, రేడియో కామెంటరీలో వినేవాళ్ళం. We used to enjoy. So this is also a case of 1937 case ఇది. So people started enjoying from their homes. So the attendance has failed. ఎప్పటికి కూడా మీరు చూడండి, ఈ అమెజాన్, నెట్ఫ్లిక్స్ ఇవి వచ్చిన తర్వాత థియేటర్స్కి వెళ్ళేటువంటి ప్రేక్షకులు తగ్గిపోయారు. Everybody is enjoying. Nowadays, even the rich people who got the big houses, they are constructing home theaters. సినిమా హాల్లో ఉన్నట్టే ఉంటుంది. సౌండ్, డాల్బీ అట్మాస్ ఇవన్నీ వచ్చేసినాయి కాబట్టి. ఆ రోజుల్లో అలా కాదు కాబట్టి క్రికెట్ కామెంటరీ లేకుండా రేస్ కోర్స్ కామెంటరీ వింటూ దే యూస్ టు స్పెండ్ టైమ్ అండ్ ది అటెండెన్స్ హ్యాస్ బికమ్ fallen down substantially. Right? So he filed a case of tort. Just like Bradford versus Pickles. In the first instance, the Privy Council, they wanted to hold that no legal injury was caused. But this tort English law, because Australia was actually being controlled by England at the particular time. English law developed and said the intention, the evil intention, the malicious intention, the intention to get some benefit is deprecated by the court, and majority members of the High Court held that there is no remedy, but still High Court held that it is irregular. Tort law, negative example. Normally in Bradford company, I told you that even though he has taken out the water from the municipality, no offense, but here it is held to be a tort. Please remember, this is a negative example. ఇలా కూడా జరుగుతూ ఉంటాయి, తెలియటానికి వీడియో చేస్తున్నాను. Please understand the essence of it and enrich your life a lot. Thank you.